Come on. We're going to look at trial procedure. These are the steps that you go through if you're initiating and going through a trial process on a civil trial, not a criminal trial. There's slightly different procedures for civil trial versus a criminal trial. First today, what we're going to focus on is the civil trial side. So all the parties to a civil trial are the plaintiff and the defendant. The plaintiff is the one who is suing. The defendant is the one who is being sued. When we have a civil trial, slightly different than a criminal trial, we have, you could argue that a civil trial is not necessary. In that it's really just my infringing upon John's rights, or one person's infringement upon the rights of another. Now, of course, if I were John and I had to go get new hearing aids because of my loud music, I of course would want to make John pay. So it is a right as a U.S. citizen to sue another party who has infringed upon your rights. But what we try to do is we try to keep those types of cases, if we can, out of court. Because court is long and it's expensive and time-consuming for both parties. So before a case goes to trial, they try to use what we call alternative dispute resolution techniques. These are to try to decide the case before it goes to trial. So the two primary types of ADR are mediation and arbitration. The distinction is that in mediation, both of them bring in a third party. The distinction is mediation, we bring in a third party who recommends solutions. So circle that, recommends solutions. They try to persuade the sides to come to a decision that's mutually acceptable. Compared to arbitration. Arbitration, the third party decides the case. Okay, so when both sides agree to bring in an arbitrator, whatever the arbitrator decides is the resolution. Okay, if you don't like it, it's kind of like too bad. So that's the distinction. The arbitrator's decision is binding. So write that down. The arbitrator's decision is binding. Whereas with mediation, it's a recommendation. It's not binding. Arbitration, the decision is binding. So let's say we couldn't satisfy under using ADR. They wouldn't agree to arbitration. We go to trial. When we go to trial, we start a civil trial with two things. One thing combined with two parts. One thing, the pleadings. And the pleadings are comprised of the complaint and the answer. The complaint outlines what it is that the plaintiff wants. What's the problem, and what does the plaintiff want as a result of the problem? The defense answers that complaint. Okay, so it's like Nicole coming up to me and basically saying, Ryan ate all the oatmeal cookies. Mom, what are you going to do about it? Okay, I'm the judge. Okay, I get to decide. What am I going to do? What does Nicole want out of it? What do you want from Ryan if he ate all the cookies? Make more. You want him to make more. Okay, so she would file a complaint with the court, and then Ryan would answer. Is he guilty or is he not guilty? Okay? So I'm going to give you an example using my mock trial case. We have a mock trial case going on right now. We're going to court on Wednesday with our team. We have our complaint. Okay? Our case involves the County of Dover and Robin Berkman. And this is exactly what a real complaint and answer would look like in a real case. So in this particular case, Robin Berkman, he was arrested several years ago for committing robbery and attempted murder. He was investigated, the case was investigated, and Officer Leslie Smith was the investigating officer. And ultimately, Robin Berkman was put into jail. He was convicted of the crime. And he got put in jail. He was in jail for 3 years. During that time, somebody came along and admitted that they committed the crime, and it wasn't Berkman. Somebody else said that they did the crime. So Berkman is turning around, and now Berkman, as the plaintiff, is suing the county of Dover for basically wrongful imprisonment and malicious police conduct. Okay? So in this complaint, they outline all, basically everything that's involved that they're suing for. So they're going to state who the parties are. This one is the plaintiff. This is the defendant. This is where the plaintiff lives. This is the police officer. Outlines who the police officer is, what the police officer did here. Okay. In the action against the defendant, in the action, defendants is alleged that the plaintiff committed crimes of attempted murder and robbery, attempted murder in the 2nd degree and robbery in the 1st degree. And a copy of the indictment is placed in the exhibits, yada yada. Plaintiff was criminally charged and was incarcerated in a state corrections facility for 3 years. Later, there was a dismissal, and the plaintiff was released from the facility. So they're outlining all the pieces of what the complaint is, what all the parts of the complaint is. Okay, all my notes on the sides are what we agree to or what we deny. So as the defense, then we answer that complaint. And we basically state what we agree to in the complaint, because there can be some things in the complaint that we agree to. The first things that we say, we agree to paragraphs 1, 2, and 3. What are we agreeing to in 1, 2, and 3? We agree that the plaintiff is Robin Berkman. We agree that he resides at such and such. We agree that the county of Dover prosecuted him. And we agree that, the detective was so-and-so. So we're agreeing. So why go to court and argue those items of the complaint when we agree with them? So you kind of go through and you answer the complaint and say what you agree to, and then you deny what you don't agree with. So first thing that we deny, what do I say? We deny that the plaintiff, we deny that the detective is responsible for the occurrences and injuries alleged in the complaint. We don't agree with that, okay, as defense. So you kind of go through and you outline what you agree to and what you don't agree to in your answer, okay? And that's the process of the complaint and answer. Then you also put together a list of what we call stipulations, okay? And these are, again, sort of affirming things that we agree to in the case before you go in, okay? You stipulate that these are the things that you agree to. Okay. And that's the start of the trial process. After that, you go through what we call discovery. In the discovery process, both sides go and they're investigating their case. You go through and you kind of take affidavits from the different witnesses. You might, which are called depositions. You might send a list of interrogatories, questions to some parties and ask them to answer a bunch of questions. You might see if you can get some physical examinations. You can request evidence. You can request admissions, request that one party agree to, you can agree that the parties maybe were involved. You can maybe agree that so-and-so resides someplace. So you request certain admissions up front. Okay? That's discovery. Then you might have a pretrial hearing with the judge. And in that pretrial hearing, you can agree that the case is going to be decided at that point, or you can move forward to trial. If you move forward to trial, the first thing that happens is we select the jury. The selecting of the jury is called voir dire. Voir dire is Latin for speak the truth. It determines if the jurors are qualified to be a juror in that trial. So, I'm going to pause this for a minute because I want to go into a little bit more detail. But in the voir dire process, basically what happens is a jury pool is selected. How many kids know if their parents have ever gotten selected for a jury? Oh, a lot. Okay. They've gotten selected or they've gotten a notice? Selected. Okay. Notice or selected? Selected. Okay. So what I want you to do is I want you to go home and I want you to ask your parents about the process of sitting on a jury. I sat on a jury once. It was really, honestly, it was fascinating. I thought it was very interesting. Maybe that's because I'm a geeky law teacher, but whatever. It was long before I was a law teacher, okay? It was when I was a banker. But it's a very interesting process. It's neat to go through. It's even interesting, honestly, to be called in for jury duty. What happens when you get called in for jury duty is they usually send you something in the mail and it says, call in on such and such dates to find out if you're going to be included in that jury pool. You call up and they say, basically, you get a number and there's a little voice recording that says, okay, jurors number 1 through 200 report to courtroom such and such in Albany County Courts. So you march your little butt down to Albany County Courts and you go and you sit in the jury room. And then they basically outline the case and then they start plucking juror numbers. And they'll say, okay, juror number 10, go sit in the thing. Juror number 55, go sit in the jury box. Juror number 4, go sit in the jury box. And they'll get 12 people, sit them in the box, and then they'll start voir diring them. They'll ask them questions that determines whether or not they would be a good juror for that particular case. And what they're trying to do is weed out people that could potentially be biased to the case, biased one way or the other. Okay, so let's say we had a medical malpractice lawsuit, okay, and then one person is a doctor, one person is a nurse, and somebody else is walking around with a cast on their leg. I can almost guarantee every single one of them is going to be released from that jury. Okay, they're going to get up there, and the sides, the attorneys for both sides are going to ask the jurors questions. So, can you please state your name and occupation for the courts? I'm a medical technician. I specialize in examining medical tests. Okay. They're going to say, okay, can you tell us a little bit more about what you do in your job? The guy might say a little bit more what he does in his job. And then the attorneys will say whether they would like to dismiss or keep that potential juror. They'll keep doing that to all the potential jurors until they get 12 jurors that they're comfortable with, that they believe would be the least biased and best jurors for that particular case. Yes?
Is there a limit to how many you can dismiss?
There are limits. And tonight you have homework, and in your homework it's going to talk about the ways that potential jurors can be dismissed. And there's 2 ways that potential jurors can be dismissed. So I won't steal the thunder of your homework assignment because we're going to go over it next class. Okay? But that's essentially what happens. And yes, there are a certain number that that can be dismissed. But the more notorious the trial, the case is, the bigger the pool of selected jurors, the bigger the pool of jurors, because it's going to take more people to get to until you get people that don't know anything about the trial. Who remembers the case of Trayvon Martin down in Florida? The kid, who was, pardon me?
It's 5 years ago today.
Oh, is that right? Oh my God, that's really weird that I brought that up today. Wow. Okay, didn't know that. But yeah, so the kid was killed by Richard Zimmerman. I can't remember the guy's name. Zimmerman, shot in the back. Blah blah blah. So that case, literally, people all around the country knew about that case. The juror pool for that particular case was in the thousands. Okay, thousands of people were brought in for them to get to 12 people. So they had to find 12 people that hadn't heard anything and hadn't framed or formed their own. All right, so that's selecting the jury. Once the jury is selected, then they go about the real part of the case. This is where there's the presentation of the arguments and evidence. And we start out with both sides doing opening arguments. And in the opening arguments, they're going to lay out, that's where the attorneys for the plaintiff and the defense lay out what they're looking to prove or disprove in the case. Then the plaintiff presents their witnesses and evidence first. This is called direct examination. When they present their questions on direct to their witnesses, I'm going to try this again. It didn't work last class. Let's see if it'll work. Nope, it's not going to work. So, get that. So, on direct, that's when you're questioning, your side is questioning its own witnesses. On cross-examination, that's when the other side is questioning your witness. So, if Llewellyn was my witness, I'm the plaintiff, I'm going to ask her open-ended questions. So, write that down. On direct, you're going to ask open-ended questions. So, can you please state your name for the court?
My name is Llewellyn Searing.
Okay. And Miss Searing, where do you reside?
I reside in Altamont, New York.
Okay. And Miss Searing, how long have you resided in Altamont, New York?
I have resided in Altamont, New York for a year and a half.
Okay. So you see how I'm asking her open-ended questions, she's answering in an open-ended fashion, multiple words, yada yada. I'm going to be on the other side. I'm going to cross-examine her. So, Miss Searing, that's your name, correct?
Yes, it is.
Okay. And Miss Searing, you've lived in Altamont, New York 10 years?
No, that is not correct.
Oh, not correct. Okay. You lived here 8 years?
No.
So see how I'm giving a specific question and she's answering yes or no. And it is, you do live in Altamont, New York, right?
Currently, yes.
Okay. So I'm asking her a very closed-ended question. She's answering it basically yes or no. Okay? So cross-examination is where you're trying to get the witness for the other side to answer questions in yes-no fashion. You're trying to direct where her questions or her answers are going to go because you want to get certain limited pieces of information out of her that help your side. Okay? So, direct examination, open-ended questions. Cross-examination, closed-ended questions. And then the other side does the same thing to their witnesses. Then the defense asks open-ended questions to their witnesses, and the plaintiff cross-examines their witnesses. Both sides get to do both things. Okay? And then both sides get to close. In the closing, each side gets to say how they proved their burden of proof for the case. Okay? And why the jury or judge should award in their favor. After that, after the closing arguments, the judge will give the instructions to the jury. When the judge gives the instructions to the jury, all he's saying is what law is going to be applied in that particular case. So, for instance, in my case that we had over here, we saw that in the original case, the plaintiff was tried for attempted murder in the second degree and robbery in the first degree. The judge would explain what is meant by in the second degree and in the first degree, because there's fine details in there that would make a decision one way, help the jurors to decide the case one way or the other, because it might be that it does satisfy the second degree attempted murder, but not the first degree robbery. Okay, so the jury has to decide if all of the elements relating to that particular crime or that situation pertain. Okay? And then the jury deliberates. They go back and they come up with a decision, a verdict, verdict is just a decision about who won the civil case. Keep in mind that with a civil case, it does not require a unanimous decision. So circle that. Does not require a unanimous decision. Does not. In a civil trial. A criminal trial does. And the reason we do not require a unanimous decision in a civil trial is because nobody's going to jail in a civil trial. Okay? Usually there's some other penalty associated with a civil trial, but nobody's going to jail. So it does not require a unanimous decision. In addition, a civil trial is based on what we call a preponderance. Write that down. A preponderance of the evidence. Preponderance means basically the majority of the evidence leans in one direction or the other. So it's based on a preponderance of the evidence. It is not beyond a reasonable doubt. So whenever you hear beyond a reasonable doubt, you're talking about a criminal trial, not a civil trial. A civil trial, majority of the evidence. All right. Then, when the judgment is given, guilty, not guilty, who's responsible for what? The remedies are outlined. Basically, 3 broad categories of remedies. Monetary damages, punitive damages, included in monetary damages are punitive damages. And then secondly, specific performance or an injunction. Monetary damages, they are amounts of money that we're seeking to compensate the plaintiff for whatever harm was done to them or punish the wrongdoer. So when you typically hear of those big awards of money, typically there's some level of punishment that's intended there. Okay? The plaintiff is looking to punish that bad person and hope that they will never do it again, and hope that anybody else that ever hears about the case doesn't ever do that again either. Okay? Specific performance is where the court requires somebody to perform some action, and an injunction is where we stop somebody. So for instance, in a civil trial, maybe I agreed to sell my house to Llewellyn. Llewellyn wants to buy my house in Altamont from me, and I agree to sell it to her. But then I back out. I decide I don't want to sell my house. I like my house too much. But Llewellyn, she's already given me money. She's already spent time, effort, etc. She decides that's the house I want. There's no other house exactly like that on that exact parcel of land. She sues me, and she wins. All she wants in the suit is for me to specifically perform and sell my house. That's specific performance. I'm going to require the court to force, she's going to require the court to force me to do what I originally agreed to do. An injunction, the court is trying to force you to stop doing something. Good case here in Guilderland, Capital City Diner, you guys know where that is, over by Crossgates. It used to be like Metro 20 Diner. Well, when Metro 20 Diner originally opened up, they were like emitting, they didn't have the proper ventilation system on their kitchen, and so they were like emitting odorous smells out into the environment. And all the neighbors around it, it was very bothersome, so they're outside having a barbecue or whatever, families over, blah, blah, blah. And all they could smell is the smells coming out of the diner. And they really despised it. So they went and they petitioned the court, sued the diner, and then the court issued an injunction that they had to stop emitting all those odors out into the environment, and they had to put a proper ventilation system to stop that from happening. Okay, so that's a typical type of an injunction. Stop somebody from doing something that's bothering somebody else. Then they have the execution of the judgment. Basically, the judgment is enforced by the courts. And then lastly, if one of the parties, one or both of the parties, don't like the decision that was decided in the case, they can appeal it. And then they go and they present their arguments to the appellate court. And I think that is it for today. Yes, we're going to stop there for today. And we'll pick up with criminal trials next class.